should know that. What happened between the two events? The jury should know that. They've been shown videos already of that.
Well,
if I may respond briefly.
Yes, sir.
First of all, what counsel's just mentioned in terms of the overall timing is something he's free to play video and argue. The question is what this expert witness can testify to. The court has ordered specifically what he can and cannot testify to. Your order is one of limitation. It specifies the limits of what he can testify to. It's a fundamental notice issue, Your Honor. In his preliminary report, he didn't have information regarding the timing from friendly. That was a report from 3 months ago. We were not put on notice that there would be this testimony through this witness as to the timing of from the very beginning of all this to the very end. This Exhibit 142 is the first document we've received, and it was received today.
It was provided yesterday.
Don't interrupt. Don't interrupt.
It is the first document we've received from the defense pertaining to this witness with regard to the timing of the entire evening. It is beyond the court's order. We have not received proper notice as to this subject. I have no problem having this witness testify to observations 8, 9, 10, and 11. That is the exact scope of the court's order. Shot 1, shot 2, shot 3, shot 4. I have no problem with him testifying as to items, observations 20, 21, 23, and 26. Those are the 4 shots in the second incident with Grosskreutz, Huber, and the unknown assailant. That's exactly what this court limited him to. Those 8 observations on this sheet of paper. Everything else on this exhibit, which we just received, is beyond the scope of the court's order. We've not been provided notice of it. It wasn't in his original preliminary report. It is being sprung on us in the middle of trial. The court has ordered on this. We had a hearing on this. The court gave the defense opportunity to put us on notice of these things. We talked about these limitations. There was an agreement among the parties as to these limitations, which led to your order, Your Honor. And now the defense is going around that order. And I object to that.
Your Honor, I asked the court to think back to what's happened procedurally in this case. That FBI video didn't come around until about 2 weeks before trial. The drone video didn't come back until during trial. And most of this work has been done over the last 2 days to catch up to those exhibits. I provided this exhibit yesterday afternoon when it was first provided. The only change to it is and was a typo, which actually inures to the state's benefit by adding approximately 9 seconds.
I quibble with counsel. The FBI video was made available to counsel over 3 months ago.
That is
I don't want to. You know what? I don't want to get into it. It's been argued about before, and then we laid it aside. And at this point, I don't think I want to get into that because it isn't going to be helpful to resolution of the issues that we're after in the case. You know, I'm looking for the order. What was the date of that order?
I think it was November 2nd, Your Honor, but I'll pull it up here.
I believe that order was drafted by Mr. Binger.
It was.
And
I submitted it to all parties. There was no objection to it. It was signed with no objection.
Okay.
And then the video came up after that.
Okay. I am. Here it is. All right. Now I say the order without objection, without really giving it a lot of scrutiny. As you know, we try a lot of cases in here, and because it came in without objection, I signed it. Thinking that it covered what I had envisioned at the time of the hearing. I will tell you what I had in mind and I haven't looked at if there is even a transcript in existence. I don't think so. But it certainly was my impression that we were talking about video of the entire episode And not that it certainly in my mind was not limited to the specific numbers on this observation point list that you're talking about. Yeah, I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to say.
I have to say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order. I submitted that draft of that order to the defense. They had an opportunity to review it. They had an opportunity to object to it. We do this all the time in the court system. We submit proposed orders to the defense, to the other side, and to the court for everyone to take a look at. If anyone had a change, an objection to that, if they wanted to expand it, there was plenty of opportunity to do so. There was no response whatsoever from the defense. They never came to this court and said, the proposed order is improper, here is our version of the order. They never came to the court and said the proposed order needs to be amended in some way. They never responded at all, even though they had it, and even though they had plenty of opportunity to do so. They have every incentive to make sure that the court's order with regard to their expert witness is accurate. They have every incentive to make sure that that court order gives them the opportunity to get in all of the evidence through this expert that they feel they need to get in. Despite having that very powerful incentive, they did not object, they did not contact the court or me with any reaction to that order. You are the referee. The parties argue about things and you make a decision. We reached an agreement on this at the Daubert hearing.
I don't think on this issue.
I proposed this compromise, Your Honor. I did, because there was some back and forth about the extent of the use of force issues and all that stuff. And I said, well, what about if we just agree, Dr. Black can talk about the timing of the shots and the sense-making. And I then drafted this order. You gave the defense an opportunity to object. They didn't. You signed it. And my recollection, and again, I know you referenced the transcript, but in his preliminary report, Your Honor, all he talks about is the timing of the shots. In Event 1, the 4 shots of Rosenbaum. In Event 2, the shots against the unknown assailant, Huber. So there's nothing further in his preliminary report about the extent of this entire time frame. This Exhibit 142 goes well beyond his preliminary report from July 31st. It goes well beyond what we talked about at the Daubert hearing. It goes well beyond what we agreed to that day. And it goes well beyond this court's order.
Yeah. If I understand correctly what's being pursued by the state at this point, is timing sequence for the time between the friendly and the surrender to the police, which he says is a total of 400 and some, or attempted surrender to the police, which he says is a total of 4 minutes and some seconds, all of which is, every second of which I think has been analyzed here in this courtroom. That was certainly my vision at the time we discussed all this, whether it was each part was specifically discussed in his preliminary report or not. That was my vision of what we were going to be hearing. And I guess the questions I have is, what is the prejudice to the state? Are you suggesting that what he's about to testify to, or may testify to, is going to be different with respect to the new periods of time than it is with respect to the particular periods that you identified in the order that you drafted? Or that's number one, as to whether there's prejudice to the state. Secondly, whether you think that there is some incongruity between the periods of time that might be more fully covered by the examination of the entire time period, because those are the principal issues. We're here, you know, and you've practiced here. You were assigned here for quite a long time, some years ago. And I think that most people would say that I'm pretty open to, I want to have the whole thing presented to whomever is finding the facts, whether it's me or whether it's the jury. I want to know as much as possible rather than try to isolate particular things and say, well, that isn't